Most people think courts have one job: interpret the laws that exist and punish people who break them. A judge reads the statute, applies it to the facts, hands down a sentence or a verdict. That's it. That's what courts do. But courts hold a quieter power that most of us don't think about at all, and it's more consequential than punishment. It's the power to declare that a law itself is invalid. This wasn't always obvious. In fact, it wasn't obvious at all. In 1803, Chief Justice John Marshall sat down to write an opinion in a case called Marbury v. Madison. The case itself was almost mundane. William Marbury had been promised a federal judgeship before Thomas Jefferson took office, but the new administration never delivered the paperwork. Marbury wanted his job. It was administrative, bitter, small, the kind of appointment dispute that happens at every transition of power. But Marshall saw something larger. He could have simply ruled that Marbury had no legal claim. Instead, he wrote an opinion that established something the Constitution never explicitly says: that courts have the power to decide whether a law violates the Constitution and strike it down if it does. This was radical because it wasn't written anywhere. The Constitution is silent on the subject. Marshall essentially argued his way into the authority. He reasoned that if the Constitution is truly the supreme law of the land, the document that binds everyone, including Congress, then someone has to enforce it. If Congress passes a law that contradicts the Constitution must prevail. And courts, by their nature as interpreters of law, must be the ones to make that call. Here's how it works in practice. Someone files a lawsuit challenging a law or a government action. The person argues it violates the Constitution. The court examines that claim. If the court agrees, it declares the law or action invalid. It doesn't rewrite the law. It doesn't punish anyone. It simply says, this cannot stand. This power is genuinely transformative. Before Marbury *, it wasn't settled that courts could do this. After Marbury *, the judiciary became a real check on the other branches. Congress could no longer pass any law it wanted. Presidents couldn't govern by whim. Courts could protect individual rights even when legislatures disagreed. But judicial review has real limits, and most people don't notice them. A court cannot simply decide to rule on a law in the abstract. Someone must bring an actual case, someone who has actually been harmed by the law or government action. The injury must be real and imminent, not theoretical. If the harm is already resolved by the time the case reaches court, judges often refuse to rule. Courts call these doctrines standing, ripeness, and mootness. They prevent courts from becoming a parallel legislature, issuing advice on hypothetical scenarios. And courts cannot rewrite laws. They can only strike them down. When that happens, Congress and state legislatures can simply pass a new law, a revised version that attempts to accomplish the same goal without the constitutional problem. The branches remain in conversation. The deepest disagreement sits here. How aggressive should courts be when they review laws? Should they scrutinize a law protecting someone's right to vote the same way they scrutinize a law setting price controls on milk? Different courts in different eras have answered differently. Some defer heavily to elected branches on economic matters and intervene sharply on individual rights. Others reverse that balance. These aren't settled questions. They reflect genuine constitutional ambiguity. Judicial review is real. It's powerful. But it's also constrained by procedure, by institutional design, and by enduring disagreement about how far courts should go. It's been the engine of American constitutional governance for over 2 centuries, and we're still arguing about how it should work.